So when the prosecution in this Ato Forson closed their case, Ato Forson and his lawyers decided that they will file a submission of no case. In criminal trials these days, it's almost to be expected that the defense people will always file a submission of no case. Who do you file a submission of no case to? You file a submission of no case to the High Court judge, the same judge. So case Ato Forson, after Godfrey Dame and the prosecution had said everything they would say, decided to file a submission of no case to the High Court judge. The High Court judge heard the submission of no case and disagreed with Ato Forson's lawyers and said, no, from what the prosecution have done, they have established the ingredients of the offense. You will need to prove your case. You will need to defend yourself. If you don't defend yourself at this stage, I'll jail you. But if you can defend yourself, I'll listen to your defense. I'll compare it to what they are saying, and I'll make a decision at the end in my judgment, as opposed to ruling. Okay. So the High Court then told Ato Forson that you have to answer. That's the question I was asking these people, my friends, this morning, that did they file a stay of proceedings? And I think I got the answer that they didn't. You can decide not to. So when their submission of no case failed at the High Court, they filed a submission of no case at the Court of Appeal, whilst the High Court continued with the case. So they opened their defense anyway at the High Court, as they were required to do by the judge, because their submission of no case failed. So when they opened their defense, then their defense, that's when Jakpa came in with all that, Setekpe came in. That is the defense lawyers defending themselves in the High Court process. Meanwhile, the appeal against their failed submission of no case was pending at the Court of Appeal. So they filed the process. When they filed the appeal, the Attorney General is supposed to respond. When you go to appeal, as they tell us in school, when you go to appeal, what is on trial is the decision of the judge that you are appealing against. So the lawyers are always keeping an eye on the Court of Appeal judges to be sure, as they say, that they are not trying the case anew. That's the language the lawyers use. That they are not trying the case anew, that they are looking at what the High Court judge did. Because what is on trial at the Court of Appeal in any process that is arising out of the High Court is the judgment of the High Court. That's what is on trial. Okay? So the Court of Appeal looked at the judgment of the High Court. They are looking at why the High Court decided that case Ato Forson has a case to answer and that his submission of no case should be denied. Why did the High Court make that decision? So the Court of Appeal is looking at why the High Court made that decision. This morning, the Court of Appeal said they have looked at the High Court judge's decision and they do not agree with her. They think that she didn't look at this, look at that, look at that. On the basis of that, they, the higher court, the Court of Appeal, are making a decision that case Ato Forson's submission of no case should have succeeded at the High Court. It didn't succeed. They are a higher court. In the circumstances, they deem case Ato Forson's submission of no case as successful. This morning, 10:20, the Court of Appeal ruled as such. Court of Appeal is 3 judges, so that we have more heads looking at what the single High Court judge did. And then when you go on to Supreme Court, you have even more heads looking at this. That is the beauty of the judicial system and the democracy. So the High Court, Court of Appeal decided today, this morning at 10 a.m., that the High Court judge was wrong. So the High Court judge is the one that the Court of Appeal is criticizing. Not the Attorney General, by the way, technically. That the High Court judge, who happens to be a Court of Appeal judge, sitting as an additional High Court judge. Next time I'll explain that. Today we don't have time. That the High Court judge made a mistake when she decided that case Ato Forson has a case to answer. Because in their view at the Court of Appeal, in the view of the majority of the Court of Appeal, the 2 of them, case Ato Forson has no case to answer. He should go away. His submission of no case is successful because the prosecution has not been able to establish a case against them that they need to answer. If the prosecution is not able to establish any case, then they don't need to answer. So that is what the High Court, Court of Appeal decided this morning. That the submission of no case, case Ato Forson says that after everything the Attorney General said, he has said nothing. I don't have any case to answer. After Bebe no kind, there's nothing in it. And the High Court judge said, who told you there's nothing in it? Come and answer. So they started answering. Court of Appeal said, 2 of the Court of Appeal judges said, I agree with the High Court. So that's what happened. Now, a submission of no case, if he succeeds at the High Court, that's the end of the case. That's the end. So you can ask Kwesi Ahoy, During the trial of Quality Grain, his submission of no case was successful and he walked away. That's the end. He's gone. It's finished. It's finished. You brought a case against me. You took me to court. You told the court about the case. The judge says that after all what you said, I don't have a case. I've not done anything wrong. So I'm gone. So when the Court of Appeal made that decision this morning, it meant that case Ato Forson is free to go. But that's not the end of the pyramid I put here. The Attorney General has indicated that he is dissatisfied with the decision of the Supreme or the Court of Appeal. Therefore, please put the pyramid back. I'll come to the Attorney General. Therefore, he is going to rise above that and go to the Supreme Court and let 5 judges look at what the Court of Appeal 3 judges decided. In any case, one of the 3 judges decided that Ato Forson has a case to answer. 2 of the judges said that Ato Forson has no case to answer. 2 is greater than 1. And therefore, in majority, Ato Forson wins. But now, the Attorney General says, no, I don't agree with that. As an appeal is as of rights, especially at the Court of Appeal, where it's 2-1. Even if it's 3-0, you still have the right to do so. But where it's 2-1, the lawyers are going to begin to watch with very eager eyes. Because the Supreme Court now has a basis to start. That there's 1 that says no, 2 say yes. Let's look at the 1 that says no. Let's look at the 2 that says yes. Let's look at Godfrey Dame's record at this time. In the Oponi trial, Oponi was able to win at the Supreme Court with a 3-2 majority. Godfrey Adame decided that no, the 3 were wrong. He asked for a review of the decision, and he won the review of the decision, and Oponi lost. That is the apex, the end of the trial. After Supreme Court review, it is called in Latin, res judicata. Please Google it. Res judicata, what does it mean? You see it. When the matter is finished, it is called res judicata. There's nowhere else to go. Because, as the lawyers say, there has to be an end to litigation. You understand? Okay, so that is what is happening now. Court of Appeal have decided by a 2-1 majority that case Ato Forson has no case to answer. He's gone. That's why they reduced the powder. Because they haven't finished. If it is the Supreme Court review, they will carry Ato Forson's body and dump it into powder. Because why? We are at res judicata. Our son is finished. But now it's not finished. It's not finished. Court of Appeal has ruled. Attorney General says, I'm going up. Viewers, I hope you understand what I've said. If you don't understand it, send text messages. Thursday, I'll come back to this topic and explain it better. Let's see what the Attorney General said as we conclude on this matter before we get to Dodo. Oh, it's 11:30 now. So the Attorney General says, in his press release, I start from the second paragraph. It says, the Office of the Attorney General considers the decision of the Court of Appeal to be perverse in the quest for public accountability and the rule of law. The decision clearly is heavily against the weight of the cogent evidence led by the prosecution in the substantiation of all the charges against the accused persons at the trial. The relevant facts of the matter, as borne out by the undisputed evidence led so far, show that vehicles purported to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. B, the then Minister for Health, Mrs. Sheriaite, had cautioned in writing against the importation of the vehicles into the country. There was thus no request by the Ministry of Health for the vehicles to be imported into the country or for the letters of credit which were means of payment for the vehicles under the contract to be established. With no request from the Ministry of Health or any authorization whatsoever, and at a time when the period for supply of the ambulances under the contract had even elapsed, the first accused, case Ato Forson, by letters of credit dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller and Accountant General to issue letters of credit for the payment of the vehicles. The letters of credit were consequently established on the 18th of August 2014. Big C General Trading Limited, the suppliers of the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on the receipt of the letters. The Attorney General is here explaining and showing why the evidence that was led is so compelling that no justice of the Court of Appeal should look at this evidence and make a decision that the submission of no case should be established. That's the matter. Bring me back the hierarchy, please. Bring me that hierarchy. And I'm rushing through because we are running late. I'm sure a lot of people will see this on Facebook tomorrow because some of our people have gone to bed. So this is the matter. This is the explanation.